This is Duke University.
Welcome and thank you all for joining us today. The Human Rights Law Society is very excited to be presenting such a prestigious board of speakers, panelists, on the topic of the Personhood Amendments. As you may know, in 2011, about 69 different measures aimed at restricting a woman's access to abortion were considered by 26 different states. 6 states actually considered what have become known as the fetal personhood measures. These are measures that define life as beginning at the moment of fertilization and grant legal personhood rights on fertilized eggs. They also have the effect of banning abortion altogether, even in cases of rape, incest, or where the woman's life is in danger. So joining us today to talk about some of the cultural, social, constitutional, and international issues implicated in these personhood measures are Dean Katherine Bartlett, Professor Ralf Michaels, Professor Neil Siegel, and Professor Darrell Miller. Thank you all so much for speaking with us today.
Great. Well, I'm going to start and moderate. Thank you all for coming. As Toddy mentioned, this Personhood USA, personhood movement, has taken many different forms in different states. Some states have movements within states have responded with proposed legislation, some with constitutional amendments or referendum. We decided, just for purpose of some focus, that we would use the language that was in Measure 26, which was voted on last November in Mississippi, which was a proposition to clarify the scope of the Bill of Rights in the state constitution of Mississippi by defining person or persons to include every human being from the moment of fertilization, cloning, or the functional equivalent thereof. So that's what we will be focusing on today, defining persons to include every human being from the moment of fertilization, cloning, or functional equivalent. We're going to start with Darrell Miller, who will be the best lawyer he can be in presenting the most positive case that he can present in favor of this movement, this language, these constitutional referendum, whatever you're focusing on. Neil Siegel will. It's clear that the main moving force of these documents is to ban abortion. Neil, I think, is going to address whether that will work, and will certainly address what the other implications of an amendment like this or legislation could be. And Ralf will discuss some comparative law dimensions, focusing on a 2010 European Court of Human Rights decision involving the Irish abortion law. So we'll try that first, and hopefully there'll be some time for questions and answers thereafter.
Okay.
Darrell?
I don't know if I've got 15 minutes worth of material, but I'll try.
10 would be good.
First I'll do a disclaimer, right? Because I don't want you to leave this room and say they had this crazy visiting professor from Cincinnati who was all gung-ho about the Personhood Amendment. I'm on the record of saying that I think there's deep problems with it, that it has a lot of imprudent, it has a lot of bad consequences. It's imprudent as a matter of constitutional law, state constitutional law, and I'll say quite happily, I'm happy it failed. But it only failed by, 55 to 45, which shows that there's some, it's got some purchase, at least among popular consciousness in some states, and at least to the extent that you've got sort of a nationwide movement of trying to do this, I think it's worthwhile to engage with the arguments. And that, for that reason, I'm going to take the position about, if I was appointed as counsel for, defending this proposition, what are the best arguments I could make? The idea being to sharpen what I think would be arguments on the other side as to why it actually is a bad idea. So The other thing I'll say is, obviously, this is not a metaphysical panel. If you ask me, when does consciousness begin? When does personhood begin? How many, souls are in the guff? I have no idea about that. So if that's the thrust of this panel, I'm the wrong person for it. But it's a purely legal matter. I'll talk about. So federalism. Right? Federalism is one aspect of this that seems apparent, which is states get to do with their constitutions what they will. And if they want to decorate it like a Christmas tree, as many states do, and they want to include, a particular bauble that says that a fertilized embryo or the functional equivalent thereof anywhere on Earth is a person, for purposes of the Mississippi Constitution, they're entitled to do that. Let's stipulate for a moment, and this is a big stipulation because I'm sure that Neil will have some objection to it, but let's stipulate for a moment that Roe versus Wade and all the abortion decisions are still the supreme law of the land, and that nothing that a state does with its own constitution can undermine that. That there'd have to be, if not an express carve out for those rights, that there would have to be one read into such a provision by courts. On that point, then, it seems like there's a pretty reasonable argument that the states can take what is an inessential, not inessential, but an unessential, I guess, essentialist approach to personhood and expand it out the way it wants to, or even shrink it. I mean, I think the parallel here is if a state wanted to say corporations, for purposes of the state constitution, are not people, and I'm sure that would resonate well with many people that are upset about Citizens United, for example. We're still having a conversation about personhood. It's just that we're doing it through the mechanism of state constitutional amendment. And if you want to contract the definition of personhood for corporations and want to expand it for embryos or for primates or for alligators, the states are able to experiment how they will, and we'll see how it works out for them. So that's the sort of federalism argument. There's the sort of traditional arguments in some of the literature that I've read about the personhood movement, about that this is simply a recognition, a codification of a set of common law assumptions. That is, the common law has always had some kind of assumptions about, if not the total personhood of a fetus or an embryo, at least some cognizance that they could have interests. They could have property interests in things like wills or trusts or estates. They would act as persons for purposes of determining the rule against perpetuities, and that if the common law, through sort of judge-made decisions, is going to recognize the personhood in this sort of half measure, why is it that the state, through its positive enactments and through its constitution, can't expand that out and simply recognize what has already been a kind of history of American jurisprudence? The third point that I want to make is really not 100% legal. It doesn't talk about what does the Personhood Amendment mean for purposes of how to read a state Bill of Rights, which, as everyone knows, can sometimes be greater in terms of its protections than the federal Bill of Rights. It doesn't ask about it in terms of this sort of traditional notion of you're codifying something that's a common law presumption already, but about the sort of expressive value of this. I mean, as we can see, on the flip side, in sort of talking about corporations as people, the term person is freighted. It's a freighted term. It has legal consequences, but it's also a way of framing a set of discussions about things. And if you talk about corporations as people, that has certain consequences about how people think about how you treat a corporation. And if you talk about an embryo as a person, that also has a certain amount of expressive value. And to the extent that a state wants to use its constitution as a protest device and simply register what is the sentiment of the people of that state about a certain aspect of policy, politics, or morality, that is, in some sense, what the sort of expressive function of the law is supposed to do, and that there is something to be said that if you ended up having this personhood amendment sort of taking off, irrespective of its actual effect on what the Supreme Court of the United States would do or on federal law, you add 28 states and they add this in some either constitutional measure or some statutory provision to the same effect. It's a signal. It's a signaling device to the federal courts and the federal branches to take it seriously. And I think that we, at least if you're on the sort of progressive side of this, sort of take that expressive aspect of a movement like this lightly at your peril, because as the scholarship on sort of expressive views of the law and popular constitutionalism has identified, that the way we frame legal arguments about things can have a profound impact on the way the court eventually looks at it. I write about guns. The fact that there was a sort of a perception that there was an individual right to bear arms that wasn't actually recognized by the Supreme Court until very recently. It was a process of this sort of expressive value of what people thought the Constitution meant being then codified, as it were, by enactment, by pronouncement by the Supreme Court. So I think that there's something to be said purely as an expressive matter about what this does. So irrespective of its actual effect on the right to choose.
Well, first I want to thank the Human Rights Law Society for inviting me to participate in this discussion. I think it's a topic that's worthy of such discussions. I think Darrell is exactly right that we failed to take the claim that's on the table seriously at our peril. I also want to say how much I've enjoyed having Darrell here this semester as a partner in crime, so to speak, and I look forward to many more conversations together. So the claim is that life begins at fertilization. And what I want to ask is what it would mean to take seriously, to take dead seriously, the claim, the statement of moral and religious conviction that life begins at fertilization. What would American law, what would American social practices, what would American political morality look like if we took that claim seriously? And I think those who assert that life begins at fertilization presumably mean to take themselves seriously, and I think part of taking oneself seriously means disciplining oneself to the virtue of consistency, right? So let's have a look under the hood and puzzle over what the consequences would be. The initial response, I think Tatiana already mentioned it, this is about abortion and banning abortion, and to be sure, it's about that. You can see the advertising on the internet, vote for this amendment, oppose abortion rights. I think at the very least, if we take this claim seriously, states may ban abortion. They'd be permitted to ban abortion. Now, you still, you've got Supreme Court precedent, and what about Roe and Casey, and wouldn't that, and to the extent Justice Kennedy is on the court and still believes in his understanding of Casey, yes, of course that's going to restrict any kind of state action. But I don't want to lawyer my way around the question, right? I want to ask a different question, which is, if we as a society, as a system of law and social practices, took this claim seriously, what would it mean, right? This is imagining a world without Roe and Casey. At the very least, it would mean that states may ban abortion. But I think it means more than that. I think it would mean that states must ban abortion. States would be constitutionally required to ban abortion to avoid constitutional violations for discriminatory enforcement of state criminal laws prohibiting murder. If a state had a general prohibition on murder and then said, well, we're going to let parents If the parents don't like the sex of the child that's born, if they murder them, we're not going to prosecute that. Right? That would be a violation of equal protection in the literal original sense. Right? Equal protection of the laws means the protection of equal laws. So you wouldn't have states just being permitted to ban abortions. It seems to me states would be required to ban abortion. As has already been mentioned, rape or incest or the both combined would be irrelevant. Right? Severe deformities would be irrelevant. A guarantee of a very short life expectancy would be irrelevant. Now, what about the pregnant woman who has an abortion? It seems to me that a state would have to prosecute her for murder. It seems to me that you couldn't just go after the doctor, right? Again, because states cannot treat some persons differently from other persons for purposes of enforcement of the criminal law without violating anti-discrimination or equal protection principles under the state constitution as well as federal law, right? So we're talking about prosecuting pregnant women for murder if they undergo an abortion contrary to a state prohibition, regardless of the particular circumstances in which they were impregnated. What about other regulations of pregnant women beyond abortion? Well, what about pregnant women who drink or smoke or simply eat poorly or not as well as they might during pregnancy? What might they be on the hook for? Could they be guilty of child endangerment? What about miscarriages, right? Would that trigger some kind of state investigation, right, or criminal look into what has happened? To the extent states conduct such investigations when a newborn, right, a child dies, it seems that the same kind of equal protection requirements would be implicated here as well. Contraception. States, it seems to me, would be permitted to ban forms of contraception that interfere with implantation. And I think there are some, I'm no expert on the technology, but there are some IUDs, right, that work in that way. It also seems to me that you could make a good argument that states would be required to ban contraception that interfere with implantation, right? If there was some question of the risk of interfering with implantation, we'd have to have an argument about how great a risk is so great, right, that the state is implicated in allowing the procedure to allow the use of the contraceptive device to be employed. What about in vitro fertilization? Right? I think it's no coincidence that those who are pushing the idea of life beginning at fertilization being very uncomfortable with, if not outright opposed to, in vitro fertilization. If it takes place at a state hospital, if it takes place at a private hospital, pursuant to state law and regulation, it seems that it would trigger state interests of the highest order and therefore substantial state involvement. And I'm frankly not sure how this would work. At the very least, I imagine a state could ban in vitro fertilization. It might have to ban it, or at least ban making more than one embryo at a time. The state might have to appoint legal guardians to protect the interests of each of the embryos. If more than one were made at a time, I don't see how you could stand by the principle that life begins at fertilization and then just allow the parent or the parents to choose to use one and just discard the others. What about court-mediated divorce proceedings in which a court has to evaluate the best interests of the children? Right? It's not just the children who are out and about in the world, but also, right, any kind of embryos that could have been made for purposes of in vitro. Other implications as well. What about tax filing requirements? Right? Do you declare the fertilized egg a dependent for purposes of tax filing as soon as you're aware of the existence of the embryo? What about welfare benefits? State or federal programs aid to families with dependent children. Can you claim the fertilized egg as a dependent as soon as you can verify that fertilization has occurred? Other kinds of implications, some of them legal, some of them more in the realm of social practice. And I'm not bringing these up in order to, right, attract smiles or laughter. Right? I think this is part and parcel of taking seriously a certain claim and thinking about what it would mean to apply it consistently. What about HOV lanes on the highway? High occupancy vehicles. Right? If 2 is enough, does that mean, right, a pregnant woman, no matter how early in pregnancy, can use the HOV lane? Oh, maybe it's not so bad, right? Maybe some of you will be thinking. What about admissions fees if kids don't get in free? right? So the pregnant woman is paying for two when you go into the public or private park. Has anyone ever been to the Carnegie Deli? You know, the size of the sandwiches? Well, what happens if you want to share it? You got to pay a sharing fee, right? You're going to have a sharing fee whenever a pregnant woman orders a sandwich in a restaurant, right? Because she's eating for two. If you think that's ridiculous, that's absurd, that can't possibly be what they mean, well, I query what does it mean to take seriously the idea that life begins at fertilization? And the last thing I want to say is it sounds in federalism, right? Because I think Darrell very sensibly made the federalist argument, and I think at one point you even mentioned the word experimentation, right? Another argument in favor of federalism is often value pluralism. Well, query if you believe, right, from the internal point of view, of someone who asserts that life begins at fertilization, is that the kind of thing that naturally ends where the state border meets another state's borders? When you're talking about taking life, taking innocent life, killing a baby, are we talking about federalism? Each state can go its own way? I mean, where this naturally ends is to federalize, to nationalize the issue, but to do it in the opposite way, right, that those who push for this think of the Supreme Court as having done this. Where this ends is a constitutional right, a fundamental right to life under Section 1 of the 14th Amendment that the Supreme Court would be obliged to protect. This ends with a Section 1 right of equal protection of the laws that the Supreme Court would be obliged to protect. This ends with congressional power under Section 5 of the 14th Amendment to remedy and prevent state violations of the fundamental right to life and the equal protection rights of the fertilized egg that various state laws or practices could be violating. So in sum, it seems to me that this is very much about abortion, but it's about much more than abortion. And in thinking for yourself about whether this is a good idea, whether you support it on balance, right, ask yourself whether you want to sign on to all of this. And ask yourself, if you don't and you want to impose limits, this is a reductio, this is extreme. Well, what is so extreme? Is it what I'm doing with it, or the absolute essentialist position, the starting point that I'm responding to? Right? It seems to me these are all natural, logical, not particularly intellectually adventurous implications of the view that life begins with a fertilized egg.
So, thank you for inviting me too. I've decided that whenever someone asks me to be on a panel and provide a comparative insight, I always will, even if I know very little about the issue, and I'll do some of the research just to make sure a comparative perspective comes in. So that's promised hereby. Comparative perspective can be three things. One, it can give you an overview over what we have in the rest of the world, and that can't be done. The second is to tell you interesting and strange stories from strange and foreign peoples. And I'll do a little of that, but not so much. And some of those are going to be Muslims, and some of those are going to be Europeans, equally strange and foreign peoples. But a third is really to broaden the array of available arguments and solutions, and also to look at types of styles in which these questions are actually discussed. And that's what I find the most interesting one in these proposed amendments, and that's what I want to focus on. So I'll first give you a quote from Islamic law to look at that, to compare with that. I'll then secondly focus on the recent decision of the European Court of Human Rights in the case A, B, and C against Ireland, to ask the question that Neil just addressed, whether this can actually be a legislative question and whether it can be left to the individual states, because we see exactly that in Europe. And this is a world without Roe and Casey, indeed. I'll thirdly ask what the actual implications of giving personhood to the embryo are in such a system in which we don't have Roe and Casey, and whether indeed all the implications that Neil very forcefully says should follow, whether they are what follows in the European context. And fourthly, I'll go broader and I'll ask some broader insights on comparative law on abortion in particular. So let me first start with the quote from Islamic law. This is a hadith, so it is a saying about Islamic law. It's not directly from the Quran, and of course the Quran itself does not speak to abortion. And here's the quote. Abdullah bin Mas'ud reported that Allah's messenger, may peace be upon him, who is the most truthful and his being most truthful, said, "Verily, your creation is on this wise. The constituents of one of you," that is, you in an embryonic stage, "are collected for 40 days in his mother's womb in the form of blood, after which it becomes a clot of blood in another period of 40 days. Then it becomes a lump of flesh, and 40 days later Allah sends his angel to it with instructions concerning 4 things, so the angel writes down his livelihood, his death, his deeds, his fortune, and his misfortune." This is biologically inaccurate. We do not have 40 days of blood, 40 days of a clot of blood, etc. And we're relatively unsure about the angel coming after 120 days and blowing in the soul, obviously. But we can see one way in which this is similar to the amendment that was proposed for the Mississippi Constitution. That is, this is an indirect way of getting at the question from which age on abortion should be allowed. It does not talk directly about abortion, but one thing is it suggests there is a moment from which on personhood exists, and that must be the relevant moment then for abortion. And so, as far as I can tell, the predominant view in the Islamic world is that abortion is disallowed strictly from the moment on in which the soul comes in. And that is when the messenger comes in and writes these 4 things, and that is after 120 days, after 4 months. So that's one thing that we see in this. This also has this indirect style of getting at the question, but the framework in which it does so is quite different from the legislative one that we find in the states of the United States. Here the idea is that actually it's up to the legislator, or say the people or the constitution makers, to determine freely what their preferred definition of personhood would be. The context that we have in Islamic law is quite different. We are in a quasi-natural law tradition, and what we have to do is reason our way through to what is the correct result based on unquestionable legal bases. So this is a type of natural law reasoning, I would suggest, and it is not, in that sense, a typical thing that would actually be left to legislators. But there's something that's interesting about this quote. This talks about stages of personhood. As you saw, blood, clot of blood, lump of flesh, and then the soul. And we find that reflected in views on the availability of abortion in Islamic law as well. So we find a differentiated solution at the different stages on the availability of abortion, because although it is strictly ruled out after 120 days, it is not strictly and universally allowed before the 120 days. Rather, the more the being resembles a human being, the more sinful it becomes to abort the human being. And indeed, Islamic law, other than our law, does not have just a dichotomy of legal, illegal, but has a continuum of different levels of legal and illegal. So I said first, this is a type of natural law reasoning, and I see this type of natural law reasoning also in these state amendments. In the basis of what they are not trying to say, we think personhood should begin at life, but they say it's a natural law idea that it begins at fertilization. But secondly, let me give you an example from the European Court of Human Rights, the recent decision, 2010, on the Irish abortion law. The national constitutions in many of the European countries and in the interpretation of the respective courts do allow a certain degree of a right of abortion, with exceptions of, not surprisingly, the Vatican, Malta, and Ireland, which has a deeply Catholic background, and therefore for some time even banned you as a pregnant woman from traveling outside the country to get an abortion outside, and by now no longer bans that strictly, but makes abortion almost unavailable in the country. On the European level, we have so far not had a strong constitutional right, especially a right to abortion. And the first thing in this decision in 2010, which is brought by 3 Irish women who were unable to attain an abortion, although they wanted one, first thing the court says is that the right to privacy that we have in the European Convention on Human Rights does not grant a right to abortion. So pro-lifers were very happy that the court did not follow Roe v. Wade and did not say there is something like a right to have an abortion. And then second, the court does exactly what Neil quite forcefully considered problematic. It said this is a matter for the state. Listen here to the quote. The question of when the right to life begins came within the state's margin of appreciation. Margin of appreciation is a term of art in European human rights law that says basically there's an area of discretion that the individual states have in the degree to which and in the kind in which they protect human rights. So the question of when the right to life begins came within the state's margin of appreciation because there was no European consensus on the scientific and legal definition of the beginning of life, so that it was impossible to answer the question whether the unborn was a person to be protected for the purposes of Article 2, being the right to life. And then the court says because this, that is the level of protection for life, is within a margin of appreciation, it also follows that the balancing of the right to life on the one hand and the rights of the woman on the other is also within the margin of appreciation for the individual states. But, says the court, that margin is not unlimited, and indeed one of the three women, the one with the most extreme case, in this case who was under chemotherapy for some time, was severely afraid that her baby would be born with severe defects, effectively had no access to any abortion in Ireland. And that was considered, as far as I know, for the first time in the European Convention as a violation of the European Convention on Human Rights. So we see then, secondly, here, in the European context, it seems to be okay to leave this question to the individual member states and to the discretion, therefore. But we should see something other that emerges, actually, from this decision. Why is this question left? I mean, we see two things, really. The one is, the question is not, therefore, completely constitutionalized and federalized, but it is to some degree. Because the court says there is a margin of appreciation, but there are boundaries, and probably boundaries on either side, up to where the individual states can go in their legislation on abortion. That is one thing that emerges from this. The second thing that emerges from it, and that might be the even more important one, is you realize why the court says this is left to the individual states. It is left to the individual states because we have no scientific or social consensus over when life begins. And that means if there is no scientific truth, and if there is no metaphysical truth, as Darrell mentioned in the beginning, then this becomes a political issue. And then it has to be negotiated in political terms and in the way in which in democracy we render decisions on contentious questions, rather than just derive the outcome from certain outside truths. And that leads me, lastly, to my point on broader insights that we can see for this question from comparative law. When the US Supreme Court decided Roe v. Wade in 1973, it turned probably the United States into the most liberal country as concerns the availability of abortion as among Western countries. Since then, we've seen two developments. We've first seen a differentiation of the law in the United States, and we've seen a further liberalization of the laws on abortion in many other countries. There is a map on the internet. It's called, I think, worldabortionlaws.com. And I don't know the accuracy of that, and I don't know if it's biased or not. If you see it, however, the United States is not an outlier in its availability of abortion in worldwide comparison. What the map does not show, and what none of these maps show, is how deeply contentious an issue is within a country and how wide apart the positions are that are held on an issue. Because if we put Roe v. Wade on one end of the spectrum, then of course we have to put these amendments on the very other end of the spectrum, if indeed they imply that abortion is unavailable from the beginning for any purposes. And it's not that the United States is the most liberal country in the world that sets us apart here, but it's the degree to which we have these extreme opposing views on the issue that really sets the United States apart from almost all other countries. Now, I'm not the first one to note this. This is something that was noted predominantly by conservative scholars in the aftermath of Roe v. Wade. So Marianne Glendon, who's now the legal advisor to the Pope, so certainly not a staunch feminist in the progressive sense, said we can learn from Europe. We can learn from Europe that intermediate solutions are possible. The same is said Don Commerce, who is a comparative constitutional lawyer at Notre Dame and wrote a lot about German constitutional law. So from a conservative side, we saw these proposals to find intermediate grounds. Now that some of the political field seems to be shifting to the other degree, we find similar points of view mentioned from the other side. You may have seen President Obama's speech at Notre Dame some 3 years ago, where he said that what we have to find in this issue is common ground, and a prerequisite for that is to appreciate the possibility of the opposing view, even if we don't share it, even if we don't find the compromise in the end. And you may also have seen how much he was lambasted for that from the left and from the right. What we see, I think, in most other countries in the world is that, first, the question of when life begins is taken into the equation, but is not directly determinative of what the outcome is. We saw that the European Court of Human Rights, although it does not give a right to abortion, nonetheless gets into a balancing test in the end. So we see first that the debate is not as essentialized as starting from a definition of life and everything else follows, but takes this instead as a political definition. And second, in very painful and often very unsatisfactory ways, seems to come to compromises or intermediate solutions. That's one thing that we observe. The second thing that we observe is that we actually have this development over time, where we have a slow adaptation to new moral views as opposed to immediate steps going one way or the other. That's something that we see in most European countries and in most Western countries. You might say those are less religious than are the United States, and that makes it easier in those countries to come to this type of compromise. But it seems to be one reason why these issues, as contentious as they still are, have become less contentious since the 1970s, when much of this was discussed, which is not something that we see in the United States. So whatever else one thinks about how abortion should be regulated and what the exact point is at which and under which prerequisites abortion should be allowed or not, we can see that it seems that other countries at least find more peaceful ways to resolve what arguably is ultimately not a metaphysical issue, not a biological issue, not a pure religious issue, but becomes in a democratic state a political issue in which the Constitution may lay the boundaries, but in which, without balancing of the interests either on a constitutional level or on a political level, it will be very hard to find ultimately solutions that pacify society. Thanks.
All right, well, thank you. Those were great contributions from everybody, and I appreciate how careful and thoughtful everyone has been. I want to offer just a couple of really quick and related points, and then solicit your questions. Professor Miller made a point, his last point, about the expressive value of the amendment, and I just want to observe that this is something that it's a kind of politics that's practiced, of course, both on the right and the left. 30 years ago, it was a big thing. It didn't happen very many places, but it was cities like Berkeley and Minneapolis would pass nuclear freeze. They would become nuclear-free zones. As if that could ever have any practical significance, but it was sending a message in a way that, you know, if enough, I don't know whether it had any impact or not, but the point is that it's sort of what people can turn to express themselves. In a way, states passing DOMA amendments was expressive, since the Constitution already allowed them to reject gay marriages recognized by other states if they were repulsive enough. Nonetheless, a lot of politics went into passing state laws to make clear that this state was a state that wasn't going to recognize gay marriages from other states. Kind of a superfluous, gratuitous act, but symbolic in the sense of its persuasion. This is one of the interesting things that was suggested to me by Ralph's comments is that this is a political issue, but it's a very funny political issue having to do with when life begins. It's almost as if it's kind of politics by default. We almost expect there will be a day when the science might tell us when life begins. But that's unimaginable, right? It sounds like a scientific question, but who knows? Probably not solvable by science. No one will be persuaded. What science would persuade anyone one way or the other? Finally, in terms of back to both the politics and the symbolic value of this debate, it's interesting that the exception where the European Court drew the line, this is not going to be a constitutional right, but it's not the rights of countries are not unlimited, was the situation where there was a strong prospect of a imperfect fetus, defective fetus, which if you're really a subscriber to the personhood movement, there's sort of a double offense there. It's not. You're treating this as not life A, and B, you're demeaning imperfect life. So in a way, it seems. I
should say the issue was also a risk to the mother's life.
Okay.
So that comes in there too, and that's the easier part.
Yeah.
Yes.
Okay. Good. Questions? Yeah.
Hi. I had a few questions. One, I'm interested. I know
Let's
that
do one at a time, just so
Okay.
that we can.
We'll start with this one then.
Okay.
I know we're talking about a world where Roe v. Wade doesn't exist, but I was wondering if you could speak, Professor Siegel, to, since Roe v. Wade does exist, what the implications of a state passing an amendment now would be.
Mm-hmm. Yeah, well, that's a fair question, and I think it. Let me start by saying that I think Ralf may sense more tension between what we were saying than I saw. In fact, I don't think.
No, I don't.
Okay, because I don't see any tension. Ralf is starting. Ralf is talking about reasoning that starts with the assumption or the conviction that there is no relevant consensus, scientific, social, and he doesn't say, but what I think is part of what's going on is, and by the way, don't talk to us about religion, right? Whereas what's going on here is there is a moral religious certainty about when life begins. And so what I'm saying is, if that's where you start, from that absolutist stance, then certain things are going to follow, right? I think that's the major difference in what's going on. And by the way, I could run the arguments in the opposite direction, right? If you're the most robust supporter of abortion rights and you say, my body, my choice, right? And as long as the fetus is in my body, right? Well, then we can start running the argument in the opposite direction. And then, right, in the 9th month, just before, right? I mean, really, you could start making those arguments. So I think absolutist positions raise troubling questions of consistency if you care about what the general political morality of a time and place is going to think or how they're going to respond. And in a world in which Roe and Casey, well, Roe is not the law. Casey is the law, or at least Justice Kennedy's most recent interpretation of Casey and Gonzalez and Carhart is the law, right? And to the extent that he's prepared to stick by that, then nothing that goes on the state level, right, is going to. I think it's. Given that you're in law school and you're a bright guy, right, there's a sense in which it's a rhetorical question because you know the answer, right? State amendments, state anything can't trump constitutional decisions of the Supreme Court. So too, with respect to contraception, you might get an interesting decision about what. I don't think there's a person on the Supreme Court who wants to go there with respect to contraception. Something that the Chief Justice and Justice Alito told us during their confirmation hearings is that they, subtext in contrast to Judge Bork, believe that the Due Process Clause protects the right to contraception. So I don't think anyone wants to go there, but as a logical matter, you could talk about the scope of the right to contraception, and could you ban forms that might prevent implantation? What other kinds of forms are available? And could you ban forms that might prevent implantation? What other kinds of forms are available? And could you ban forms that might prevent implantation? What other kinds of forms are available? And could you ban forms that might prevent implantation? What other kinds of forms are available? And could you ban forms that might prevent implantation? What other kinds of forms are available? And could you ban forms that might prevent implantation? What other kinds of forms are available? And could you ban forms that might prevent implantation? What other kinds of forms are available? And could you ban forms that might prevent implantation? What other kinds of forms are available? And could you ban forms that might prevent implantation? What other kinds of forms are available? And could you ban forms that might prevent implantation? What other kinds of forms are available? And could you ban forms that might prevent implantation? What other kinds of forms are available? And could you ban forms that might prevent implantation? What other kinds of forms are available? And could you ban forms that might prevent implan right? So you could have a conversation about that, although I don't think there's much appetite for that. But you're certainly right that given that you don't have a Section 1 right or equal protection rights that attach to a fertilized egg, you have them rather, for the time being, to a limited extent, attaching to the pregnant woman, right? These implications that I'm talking about are not going to take place.
It does seem to be some appetite by some potential presidential candidates that you don't see on the court.
Oh yeah,
to revisit.
No, yeah, absolutely, and that of course is where a future nomination is going to come from.
I'll just weigh in because I also teach civil procedure, so I always have to have a civil procedure angle. So I suppose to the extent that you had some sort of question about the viability of a certain type of tort action that was brought in diversity in federal court, right? And the judge had to sit there and think, well, I got to sit as if I am a judge in the state of Mississippi, and would they recognize this type of tort suit? Then I suppose you're implicating the sort of federal judiciary in advancing what would otherwise be state policies about this. But I think that Neil is right. There's a lot of this that is just simply a protest. It doesn't do anything. It can't gin up. I mean, that's why it's strangely oversold. It can't gin up a case or controversy. At least I can't imagine how it would come up. But it just has a lot of sort of rhetorical power. And I think that a lot of it is just about sort of reframing how people sort of talk about embryos or fetuses in a way that will influence other actors in the political and judicial sphere.
I'm going to come right back to you if there are no other questions. But there are. So, yeah.
Could you talk to us about the religion angle on this? Specifically, I guess I'm thinking in terms of someone who did not conceive of personhood beginning at conception.
You want me to speak on it?
Well, no, I mean just the panel generally. I'm sorry.
Well, I mean, if you're going to make me go back to Sunday school, right? There's some line, and it shows how ignorant I am of the Bible. But it gets thrown around about how I knew you before you were knitted in the mother's womb, right? That's the trope that the trope is that the person has some sort of existence even before they are people, if you can imagine that. And I'm not a Catholic, but I suppose if you pressed me, that'd be sort of one of the impetuses for why, for example, Catholic doctrine is against contraception, is because the mystery of the fact that you are denying the person that exists in God's mind of existing is itself an affront. And it's even more of an affront if you actually do have a person that's there. But if anything, that would be an argument that would go even further than what Neil has sort of proposed about contraception. And I guess maybe as a matter of politics, you can get a lot of Protestants on board with the idea that a person begins at conception on this theory, but you can't get back before that.
I think one of the things you see in looking at the websites on this is a very deliberate effort, I assume it's deliberate, to cast this in natural law terms, as Ralf mentioned, to avoid some legal challenge on the basis that it's establishing some specific religious version of when life begins. In the back.
I have a question related to you talked about the dangers of potentially inconsistent applications if something like this were enacted. I guess I had a question regarding the Unborn Victims of Violence Act, the 2004 federal law that effectively provided criminal law protections to an unborn child. I mean, they basically said child in utero, which classified any at whatever stage of development. And they did have a specific carve-out that abortions were not, would not be considered criminal under the statute. So I had a question. That law does seem to kind of meld these two, like you said, potentially inconsistent positions. And I don't know if you could speak to, I mean, maybe if that in fact is a successful melding, or if there's just still that lingering inconsistency, maybe a theory of like justifiable homicide or something like that.
Well, there are state laws that now, or certainly state prosecutors who interpret their laws now to make it criminal for pregnant women to do certain things that are, manifestly dangerous to their fetus. Is that the kind of thing you're referring to?
It's similar. I mean, this is a federal law, but it's a similar type of purpose. Like if a person was murdered and was pregnant, then it could be a double homicide. Right. Or example.
Yeah. So, I mean, the way these child abuse cases have, or child endangerment cases have tended to go is that courts have said that unless the state makes very clear that its purpose is to reach this kind of conduct, the statutes are narrowly defined to exclude it. So the effect of this kind of language would make it easier for a court who wanted to allow one of these prosecutions to go forward.
I mean, the way I understand the law that you're talking about, and I think it's good that you point our attention to it. I think of it as a compromise, either a compromise among folks with very different views about the moral status of a fetus, or an incremental, pragmatic move by those who oppose abortion rights, right? Because the whole subtext, and sometimes not the subtext, of these debates over if you kill a pregnant woman, it's 2 murders, not 1, right? I think a lot of the impetus in politics for that is undermining the case for abortion rights, right? In increasing the moral status of the fetus. These are 2 people, right? Well, how can you say that it's a double murder and then say that we can allow abortion, right? And so you can say that on the one hand they're doing that, on the other hand they're having a carve out for abortion rights, because for the time being abortion rights exist. But I don't see that as a sort of principled, consistent melding. I see it as either a compromise among different points of view or a push by folks with one point of view to sort of incrementally, pragmatically undermine the case. I think you saw a similar kind of thing going on with so-called partial birth abortion, right, and the federal law banning that. The politics, I think, behind it is this is a kind of abortion procedure that we've got the public on our side, right? Let's just talk very graphically about what this procedure entails. At the very least, they're going to oppose that, right? And I think the politics is this is one step on the path to overruling Roe and Casey. And it's very interesting to think about what Justice Kennedy does with it, right? The politics is let's analogize this to abortion more generally eventually. Justice Kennedy distinguishes them and says this particular procedure is sufficiently unlike the kind of abortion right that I'm going to protect under Casey, that it's okay for the state to ban this if we still preserve that, right? So it's a very interesting way in which the law and the politics are both moving in the same direction, but also the law at the same time is pushing back.
Yeah.
I have a question that's something that you raised, Professor Siegel, about how if you adopt these sort of personhood statutes, it's not going to be able to stop at the border. It's about something greater, and that, a matter of life and death and murder can't just stop at the border. But today we're at a stage where same-sex marriage does stop at the border. So you're married up to the border's line. How much of that is that these are just 2 very different things and those 2 realities can coexist, or is one of those going to have to give way and that same-sex marriage will have to be either federally banned or federally?
No, it's a great question, and it allows me to clarify my claim. My claim is not a prediction about what is going to happen, right? Because politics and law is messy, right? And there are lots of different incompatible views. It's a claim about what does it mean to start from this moral and religious conviction and really mean it. And let's trace out the implications. If you're someone who identifies with this claim from the internal point of view, right, it's a reason for action or inaction on your part, then as a matter of conviction, as a matter of principle, it ought not to stop at the border. And that's exactly what's going on with advocates of gay rights. This is a question of fundamental rights. This is just like, or if not just like, enough like what we used to do to African Americans. Right? We're not going to experiment anymore with that. We're not going to have value pluralism anymore. Right? We're one national community, and we can't treat our own in this disgraceful kind of way. Today, there's a certain core of agreement with respect to race. Right? There's still very much disagreement with respect to sexual orientation. So I think it's the same thing as a normative matter. If you have that view about what's at stake with respect to equal citizenship stature for homosexuals, that's not a federalism argument. Right? That's not saying we just don't want to do this anymore in our community, but by all means, oppress my fellow citizens in some other part of the country. Right? So I think to think about it just in terms of federalism, you see advocates of gay rights doing that pragmatically, strategically, those who are saying, I'm really worried about what's going to happen if Olson and Boyes make it to the Supreme Court and is Justice Kennedy ready? Right? But it seems to me the logic of the claim is very similar to the logic. This is a universalizing logic. Right? It seems something that if you really believe what you're saying, you would want to nationalize in a certain direction.
That's true on both sides, because the people who think that marriage is only between a man and a woman are equally...
Exactly.
It's a definitional, natural law proposition. It's not a...
And if the court won't do it, we'll get a constitutional amendment that will.
Let me add a perspective to that, though, because the stops at the border is a conflict of laws question, right? The question is, to what extent does one state, in fact, have to recognize a marriage entered into in another state? And prior to that, under what circumstances can someone from out of state actually be married? And you know that Massachusetts in the beginning thought about limiting the right to marry to Massachusetts domiciliaries, and we've had an extension of that. We have a lot of these conflict of laws discussions in the United States on gay marriage, and if we had unlimited duty of the states to recognize gay marriages entered into out of state, then obviously in effect we would get to something very close to a federalization of the question, because anyone who had at least the money and ability to go to a pro-gay marriage state and get married there and could go back and then would be considered married. That would be the same solution through conflict of laws without actually federalizing the question. We have slightly less of that in the abortion context because abortion just plays out in different ways. But of course we've had examples, in Ireland was such an example that actually stopped you at the border if you went to England to have an abortion for some time. So tried to ultimately keep the issue within its boundaries. To the extent that you have the ability to travel across boundaries as you do in Europe now, some of that tension therefore goes away from that. Although, again, you have to have the money to get to England, the organizational capabilities and all of that. The point is just, the alternative is not just each state for its own or a uniform solution, because in between is, even if states have different solutions, there are more or less degrees to which one state has to recognize the regulatory choices of another one, and that is an important element in this. And I was actually very pleased to see in the gay marriage issue how much of that came to the fore suddenly of the otherwise neglected field of conflict of laws, and how central that suddenly became. I teach that too, yeah.
I told them no imperialism, but it takes over. Did you want to have a question, Todd? Okay, because I think we can come back to Dartmouth. Yeah.
I understand the idea of consistency, especially in cases of rape or incest. Do you see a consistency problem where there's an exception for protection of the life of the mother? Or would there be able to be like a self-defense protection of the mother carve out there?
It's a great question, and I didn't mention that for just the reason you identify. Right? When you're talking about those competing kinds of harms, and right, one life is at stake, a life's at stake no matter what you do. Right? It seems to me you're on stronger grounds, right, to argue that you could have that kind of carve out. Now, when you get into the real world and there's a threat to the life, but you can't quantify how great a threat. When you're talking about severe physical damage, but not death, right? Then I think it becomes more difficult.
All right, well, I hope you'll all join me in thanking our panelists for coming today.
Produced by Duke University. Online at duke.edu.